Hey y'all, Van Lufa here. Okay, we are going to wrap this up. Just because I want to finish this series, I'm going to go ahead and film this video of the closing arguments that were yesterday. I just feel like it needs to be done because I don't want to leave this series undone, if you know what I mean. So we are going to get started today. I have a nursey shirt on. Okay. So this might take a while, but we're going to just get right into it. Closing arguments on April 19th, 2021. First, when the jury came in, they were given instructions by Judge Cahill. There were 3 charges brought. Each count is separate and distinct, he said. Consider each count as if it's the only one brought before you. Each count has a separate verdict. And then he started defining some words so that there was better understanding of the language in the charges. He defined the words and phrases attempted bodily harm, substantial bodily harm, causing death, superseding cause, intentional, intend or intent, police officer, and law enforcement agency. Then they started discussing the counts. Count 1, murder in the second degree. Causing the death of another without the intent of causing death to another while committing or attempting to commit a felony is guilty, he said. And there were 4 elements to that charge. Count 2, murder in the third degree. Causing the death of another by perpetrating an act imminently dangerous to others and I can't even read my own handwriting. Others and evincing a depraved mind without regard for human life, but without intent to cause death is guilty. And that particular charge had 5 elements to it. Apparently, all the neighborhood dogs today feel the need to fight while I'm filming. Count 3, manslaughter in the second degree. Whoever by culpable negligence whereby the defendant created an unreasonable risk and consciously takes the chance of death or great bodily harm cause the death of another. If they do that, they are guilty. And that particular count had 3 elements. He talked about the evidence given during the trial and how that all comes into play. Then the prosecution stepped up to start the closing arguments, and this was Steve Schlescher. I pronounce it a completely different way, but it is pronounced Schlescher. He started out with kind of a slideshow talking about George Floyd and his family. He showed the same pictures that his brother showed when he was on the witness stand as a Spark of Life witness. Talked about his childhood. He spoke about the 9 minutes and 29 seconds. He talked about how he died. He showed a picture of the cops on him from a still photo from the milestone footage. His final words on 525 were, "Please, I can't breathe," and begged for help, but the defendant continued to kneel on him. This was a call about a counterfeit $20 bill. All that was required was compassion. Humans need that. People need that. But during that time, George Floyd needed some oxygen. He needed to breathe. The defendant heard that over and over, but he continued by assault, even beyond having a pulse. He had to have known. Then he talked more about the cause of death, how it was ruled a homicide, what they did that killed him exactly. There is nothing worse for good police than bad police. Not all police are on trial here, he said. Just Mr. Chauvin. He is not on trial for who he was, but for what he did. He knew better. He just didn't do better. The chief of police said he violated policy. He did this on purpose, and that 9 minutes and 29 seconds is what killed George Floyd. He betrayed the badge and what it stands for. He had his pride, and he was not going to let these bystanders tell him what to do. They were powerless. He chose pride over policing. talked about Charles McMillan telling Mr. Floyd, "You can't win." He said, "I'm not trying to win." The defendant was trying to win, meaning Mr. Floyd was trying to win. Or, excuse me, Mr. Chauvin was the one that was trying to win. George Floyd paid for it with his life. Mr. Floyd is not on trial here. He said the defense will tell you that he was being non-compliant, and he gave examples of how he was compliant. He played a video of them trying to put him into the car. They talked about stuff that the defense witnesses said and that they aren't required to believe them. And he called the defense witnesses nonsense, not common sense. And then he discussed a murder in the second degree. He showed a slide that had all the elements on it and what they needed to, what kind of a decision they needed to come to, say he was guilty of that. Then they showed more pics and talked about substantial bodily harm. They showed the third-degree murder charge and discussed that. They showed some videos of the bystanders questioning him. Then they went back to third-degree murder instructions. Then they talked about the second-degree manslaughter slide and talked about what it involves. They discussed being a threat versus being a risk. There were 4 officers there. There was no need to do this. He wasn't going anywhere. He was talking about all of the witnesses who agreed this was not reasonable use of force. And again, he stated he knew better. He just didn't do better. And at that point, the prosecution ended. And then they took a break because, of course, they took a break. State's rebuttal by Eric Nelson. First, he thanked the jury. He apologizes that if he gets too long-winded, the state gets to rebut, but he only has one shot, he said. So he talked about 2 crucial laws that he was going to talk about here today. Number 1 being the assumption of innocence, and number 2, proof beyond a reasonable doubt. Then he defined what proof beyond a reasonable doubt meant, and he also talked about the burden of proof. The evidence supports the action. The 2 things work together. He encouraged them to take their time to carefully read through the instructions. You need to review the entirety of the case. Some of the videos you saw were much longer than what you saw, and I'm going to show you those today, he said. Dr. Fowler testified that carbon monoxide from the car could have played a part in the oxygen deprivation. And in a rebuttal, the state brought back Dr. Chauvin, who said, "We can disregard that." I could have argued, "We know this wasn't asphyxiation because Mr. Floyd had a 98% oxygen saturation level, but a paramedic testified he was given oxygen, so that would not be very honest of me to say." So he was trying to say, "Hey, I'm honest, believe me." Then he went over the manslaughter in the second degree again. He explained the elements to that. He used a reference that, so he used a little metaphor or a reference to try to explain them how they need to come to this. It's the same as baking chocolate chip cookies. You have to have all of the ingredients. If you are missing even one, the cookies won't turn out. So he said, if you are missing even one single element, then he is not guilty of that charge. They discussed all of the things a reasonable police officer has to take into an account at the scene. During this trial, the state has focused your attention on those 9 minutes and 29 seconds. The proper analysis was putting that 9 minutes and 29 seconds into context with the rest of the time. He went over the written transcript of the call to dispatch, showed officers arriving at the scene of Cup Foods. He showed more of the call transcripts, and these were call transcripts of the radio calls to dispatch that the officers made during the incident. They have a video of Chauvin showing up at the scene. They talked about use of force definitions, more video of Floyd getting into the car. They showed a slide about de-escalation. It's when Mr. Floyd gets put on the ground, that's reasonableness is what gets disputed, he said. The 9 minutes and 29 seconds completely ignores the previous 16 minutes and 59 seconds. More videos of Mr. Floyd on the ground. He mentioned that during this trial, he could not see 4 of the jurors, and he used that as an example of talking about perspective versus perception. He discussed some of the state's witnesses and their perception of what they saw versus what was really going on. The bystanders do not know exactly what went down prior to their arrival. More bystander videos than they showed. They just defined crisis intervention and described the crowd in crisis. They show a video of Floyd taking his last breath and then 2 other things happening simultaneously at that time. Mr. Chauvin took out his mace because the crowd was threatening him, and Genevieve Hanson startles him when she walks on up. So Genevieve Hanson, if you remember, was the Minneapolis firefighter who happened to stumble upon the scene. And because of those things, that changed Mr. Chauvin's perception at that moment. They talked about MPD policy. When do you stop doing CPR? When it's not safe. The paramedic determined that the scene wasn't safe also. They discussed the trainer who said that neck restraints were authorized to use. They talked about non-deadly use of force. They defined the word intent. Officers know they are being recorded. Do you think somebody would intentionally do something when they know that they are being watched? More videos. All evidence shows Chauvin was using his training. He keeps apologizing for being so long-winded, and boy was he. He goes over the cause of death, talked about Dr. Tobin and Dr. Smock, tried to discredit them, as well as the other MDs. He was trying to kind of discredit them. He read the definition of homicide and called it a medical term. Dr. Thomas speculated what she said, but Dr. Thomas speculated what Dr. Baker said. He discussed Mr. Floyd pushing his knuckles into the tire and the street trying to get air, but this was done 15 seconds after Floyd was put on the ground. So he was trying to imply that he wasn't doing that to try to get more air in, since he had just done it after 15 seconds of being on the ground. He went on to breathe for an additional 5 minutes and 51 seconds. They showed more video. Then he starts talking about the toxicology. And he said he is not suggesting it was an overdose death. It was a multifactorial process. And so you have to look at everything that came into play. He talked about pills found in the cars. And he said it was incredible to him that the medical experts minimized the amount and timing of the drugs found in his body. And then the judge interrupted him and was like, yo, we need to go to a lunch break. And they did. Then we are back, and Nelson promises he'll wrap it up soon. Talks more about toxicology, talks about hypoxia. Then he gives a timeline of the gives a timeline from the time he got to the ground until Mr. Floyd took his last breath. He defines superseding cause. He gives a medical timeline. He questions what would have happened if EMS would have done resuscitative efforts right away. But he said, I'm not suggesting to you that the paramedics did anything wrong. But it raises the prospect of that continued delay in resuscitation. Mr. Nelson, your client was the one that started the delay in resuscitation, just saying. What if the paramedics gave him Narcan? Again, I'm not blaming the paramedics. Go read up on why Narcan wouldn't help somebody who doesn't have a pulse. Just go read up on it. Then they sent the jury back to the room. the judge had some issues to discuss with the lawyers. The state had a motion for clarification of the word intent. Nelson, he said Nelson misspoke about it. The judge denied that motion. Nelson said Mr. Chauvin thought he was following training, but there was no testimony by Mr. Chauvin. Nelson doesn't recall. Okay, so what Mr. Nelson said was that Mr. Chauvin really thought he was following his training, to which the state said, how do we know? He didn't testify to that. And then Nelson came back and said, I don't even recall saying that. He did. The judge said it was a reasonable inference. They reread the statement on causation to the jury, and the judge denied that motion. The jury comes back. Nelson starts to argue, and then the judge tells him to hold that thought. The judge tells the jury he's going to reread the instructions regarding disregarding certain statements when the lawyers give you advice about the law and the judge didn't. So basically he's saying, I give you the law, don't listen to the lawyers when they try to give you the law. You listen to me. Okay, here we go. Rebuttal by the state. And we got Jerry Blackwell, who is now, I consider, the biggest badass on the prosecutionary team. Okay, rebuttal by Jerry Blackwell. He stated there was a 46th witness. They did call 45 witnesses to the stand, but the 46th witness is common sense. Oh, he was snarky today, guys. Feisty, snarky. Even a 9-year-old girl understood it and said, get off of him. Why would he continue to do that to a man who is defenseless, handcuffed, and not resisting, who isn't breathing, who doesn't have a pulse, and to do that for another 3+ minutes, and to continue to do it even after the ambulance shows up? How is that a reasonable exercise in the use of force? Does a reasonable officer do that? He said Mr. Nelson didn't give facts, but stories. So this started a whole thing with Nelson because he was using the word stories a lot. Not one witness said he had excited delirium. Dr. Baker said he died of homicide, and you were told that homicide was a medical term. That's not what Dr. Baker said. Dr. Baker said homicide is being killed at the hands of another. Deadly force was used. He was in the prone position. It affects your breathing. He also had PEA. The most common cause is low oxygen. He didn't fake that. You can't make that up. He said all the facts were based on science. No human could have survived this. He showed the MPD mission statement. This badge is not a license to misuse the public or not follow proper procedures, or to not render aid when it is necessary. He said the bystanders didn't deserve to be called unruly because they weren't. They felt helpless. The judge asked him to stop using the word stories because he used it several times. And so he did. The carbon monoxide, let's see. So he said about the carbon monoxide, what reasonable person would put a person in front of a tailpipe of a car and then use it for a defense? And then he said, why are we talking about pills that were found in the car and were not even in his system? He's got a point there. There was no evidence he took the pills in the police car. He was handcuffed. 3 medical examiners have done almost 15,000 autopsies, and not one testified a person who had no pulse spontaneously came back to life and rampaged the city. You see, that is Halloween movies, not real life. He discussed unreasonable use of force. He didn't get up. Not even when the ambulance was there, Mr. Chauvin did not get up. You were told Mr. Floyd died. Okay, so this is his closing statements. These are the last things that were said in the trial, so you know he had to make it good because he's good. He said, you were told Mr. Floyd died because his heart was too big. After seeing all the evidence, you know the truth. The truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small. Booyah. Okay. Then they had The jury had more instructions on how to contact the judge if they have any questions. They discussed for quite a while what bias is. You must have a jury foreman. You should not surrender your personal opinion because others disagree. He explained how to fill out the verdict forms. And then he said, the case is in your hands. It is serious and deserves your careful consideration. And then he swore the deputy in. Then he said the alternate jurors don't need to go into deliberations. They were to go to meet him in his office so that he could give them instructions. And the jury left to go to deliberation. This was at approximately 4 p.m. Minnesota time. Then he says, we are still on the record. Defense has concerns about prosecution belittling the defense. Nelson thinks it warrants prosecutorial misconduct and is grounds for a mistrial. Stories. He said, so they called them stories. Stated that we misrepresented facts, that I put words into Dr. Baker's mouth. Then he called them fabricated facts after he was told to stop calling them stories. Then he gave an example of State versus McDaniel in final argument to the jury. So apparently this case, State versus McDaniel, must have had something similar happen with belittling the jury. Prosecution cannot belittle the defense. There's a lot of laws on this. The judge said he dealt with the objections and told the jury to disregard it. He thinks it was handled adequately. Another motion. Over the weekend, a member of Congress made threatening statements towards the jury that if there was a not guilty verdict, there would be further problems. Given the fact that this jury has not been sequestered, and it was my opinion they should have been all along, they have not been continually told to stay away from the media in this case. There is a high probability that members of the jury have seen these comments. As mentioned, one juror lives in Brooklyn Center, which is where the last police officer shooting took place. He said, this trial is so public and getting media attention, which is profound, and found its way into 2 TV shows recently. It is impossible to stay away from it. No instructions have been given about any of this. Judge said, to be fair, I have told them not to watch the news. And then Mr. Nelson goes on to say that he has received thousands and thousands of emails. He said, so the jury can't be free of taintedness. He said, the fact that we have United States representatives, and then I looked it up, and it was Congresswoman Maxine Waters from California who made some comments. The fact that we have United States representatives threatening violence is mind-boggling to me. Judge says, well, then you may have reasons for an appeal, and maybe this whole thing will be overturned. But then he wanted to know how the state responded. If there is an appeal, these statements will be used about the congressman as proof, and the statements have to be shown. So basically what the state was saying was, you're told this. You're told it was on TV, like into 2 TV shows. You were told this congresswoman said this. And I think I talk about it. Yeah, I think I talk about it further down. Basically what he said was, you have to come with proof of this stuff. You don't just get to say this stuff. You have to prove it. He called them allegations without proof of evidence. The judge said the jury has been given instructions and they are not to let any outside influence sway their opinion. And let's see. Without any evidence that the jury was swayed in any way, this motion should be declined. Nelson said he can supplement the record with that evidence, and the judge said he could. They discussed the Congresswoman Waters again. He said he could submit press articles proving this. Another thing, I thought I had written it down, but okay, it's coming up. And then the judge is pissed that the Congresswoman did that. And the judge was pissed, and he made it known he was pissed. He said it was abhorrent that she did that. But he trusts that the jury did what they promised to do, and so he denied the motion. There was also Mr. Nelson commented there was a juror, there's rumor that a juror was talking to a major media outlet, but it was hearsay. The judge contacted the media outlet and they said it was a major media outlet. The media outlet took it seriously and reached out to every reporter, and he assured the judge that it never happened. Then they talked about writing down, documenting all of the objections that were made during the court by both sides. It has, I guess, something to do with the appeal process. Then they discussed the Blakely notice. And then Mr. Nelson did like an oral waiver. So I looked it up because I didn't know what it was, the Blakely waiver. So I'm just going to talk about it for a second. The Blakely waiver is a waiver of certain sentencing guidelines by a criminal defendant during plea negotiations. It is a waiver of the right to trial on sentencing factors that may be used to increase or enhance sentencing. In a Blakely waiver, the defendant gives up the right to a jury or court trial on any sentencing factors and consents to the judge's determination of the existence of any sentencing factors within the judge's discretion as allowed by applicable laws and rules of court. So it's my understanding that Mr. Chauvin waived his right and wanted the judge to make any decisions. And that wrapped up the closing arguments. Again, crazy, crazy day. But anyway, we know how it ended. My next video will be about that. However, wanted to get the closing arguments in so you could hear them for yourself. Thank you guys so much for watching, and I'll see you on the next one. Bye.